Hello everyone, and welcome back to Nova Real Estate Solutions. Today I'm going to explore a topic that's crucial for anyone involved in estate settlement: the role of an executor in the Virginia probate process. This is a complex area with many legal and financial considerations, but I'm here to break it down for you in a clear and understandable way. Whether you're currently an executor navigating this process, or you're simply curious about what it entails, this video will provide a clear roadmap to help you understand your responsibilities and feel empowered to handle them effectively. First, let's define what probate is. Probate is the legal process where a deceased person's estate is settled under the supervision of the court. It's essentially the legal framework for wrapping up someone's financial affairs after they pass away. If you're named as an executor in a will, you're the person in charge of ensuring the deceased's wishes are carried out, as stated in that document. It's a significant responsibility that requires careful attention to detail. And in Virginia, there are specific steps and timelines you'll need to follow. I'll explore these steps in detail, providing you with the knowledge and resources you need to navigate this process with confidence. So what exactly does an executor do? Let's break it into 5 main responsibilities, along with the timelines and the forms you'll need. Remember, these are general guidelines, and the specifics of your situation may vary. Always consult with an attorney or probate professional for personalized advice. The first step is to locate the original will and file it with the circuit court in the county where the deceased last resided. This must be done within 30 days of the person's death. Why is this timeline so important? Well, promptly filing the will initiates the probate process and allows you to officially begin your duties as executor. Delays can complicate the process and potentially lead to legal issues. To officially qualify as the executor, you'll need to take an oath before the court, affirming that you'll carry out your duties faithfully. In some cases, the court may also require you to post a bond, which is a type of insurance that protects the estate from any financial mismanagement. Once you've qualified, the court will issue letters testamentary, a legal document that grants you the authority to act on behalf of the estate. This document is crucial because it allows you to access the deceased's accounts, sell property, and distribute assets. To begin this qualification process, you'll need to file Form CC 1651, titled Qualification of Executor Administrator, with the court. This form gathers essential information about you and the estate. Next, you'll need to identify and take a comprehensive inventory of all the assets in the estate. This includes everything from real estate, bank accounts, and retirement funds, to personal belongings, vehicles, and investments. Basically, anything of value that the deceased owned needs to be documented. This step can be quite time-consuming, especially if the deceased had complex financial affairs. It's important to be thorough and meticulous in your inventory. You may need to contact various institutions, such as banks, investment firms, and insurance companies to gather all the necessary information. In Virginia, you're required to file an inventory report with the Commissioner of Accounts within 4 months of your qualification as executor. This report provides a detailed account of the estate's assets and their estimated value. You'll use Form CC 1670, also known as the Inventory for Decedent's Estate, for this step. This form requires detailed information about each asset, including its description, location, and estimated value. Accurate record keeping is essential throughout this process, as you'll need to provide documentation to the court. As the executor, notifying creditors is a crucial step to ensure that all valid debts are paid from the estate. Virginia law requires that you provide notice to creditors in two ways. First, you must place a notice to creditors in a local newspaper once a week for 2 consecutive weeks. This public notice informs any potential creditors about the probate case and gives them an opportunity to come forward with claims against the estate. Second, you must send written notice to all known creditors. This includes anyone the deceased owed money to, such as credit card companies, banks, medical providers, or individuals. It's important to use certified mail with return receipt to ensure that creditors receive the notice. Keep records of all notices sent, as you'll need to provide proof of notification to the court. Creditors typically have 6 months from the date of the first newspaper publication to file their claims with the estate. It's your responsibility to review these claims and determine their validity. If a claim is disputed, you may need to negotiate with the creditor or even involve the court. You'll use Form CC 1486, the Notice to Creditors and Beneficiaries, for this step. During the entire probate process, you'll be responsible for managing the estate's assets to ensure they are preserved and protected. This is an ongoing duty that requires careful attention and may involve a variety of tasks. For example, if the estate includes real estate, you'll need to maintain that property, pay property taxes, and ensure it's insured. If the estate includes investments, you'll need to manage those investments prudently to avoid any losses. In some cases, you may need to sell property to pay off debts, cover estate expenses, or distribute assets to beneficiaries. If you need to sell any estate property, you may need to obtain court approval. This involves filing additional forms, such as Form CC 1684, the request for sale of real estate, and providing justification for the sale. Once all debts, taxes, and creditors' claims are resolved, you can finally distribute the remaining assets to the beneficiaries according to the terms of the will. This is often the most satisfying part of the process, as you're fulfilling the deceased's wishes. However, it's crucial to ensure that all distributions are made accurately and fairly. You may need to obtain receipts from beneficiaries and keep detailed records of all distributions. Afterwards, you'll need to file a final accounting with the Commissioner of Accounts, providing a comprehensive report of all income, expenses, and distributions made during the probate process. This accounting demonstrates that you fulfilled your duties as executor and allows the court to close the estate. You'll use Form CC 1680, the account for decedent's estate, for this final accounting. Generally, this final step must be completed within 12 months of opening the probate case, although extensions may be granted in certain circumstances. Now, being executor isn't always straightforward. Challenges can arise, such as disputes among the heirs, difficulties locating assets, or dealing with complex creditor claims. Unexpected issues can pop up, requiring problem-solving and decision-making skills. For example, what happens if a beneficiary contests the will, or if you discover a hidden asset, or if the estate doesn't have enough funds to cover all the debts? These situations can be complex and emotionally charged. Again, if you're facing any challenges during the probate process, Don't hesitate to seek professional help. An experienced probate attorney can provide legal guidance, help you navigate complex situations, and protect your interests as executor. As a certified probate expert, I'm here to guide you through the real estate aspects of the process, whether that means selling a home, determining the property's value, or dealing with any real estate-related issues that may arise during probate. I can provide expert advice, help you understand your options, and ensure that the real estate aspects of the probate process are handled smoothly and efficiently. And there you have it. The key responsibilities of an executor in the Virginia probate process, along with the required timelines and forms. It's a role that requires organization, patience, attention to detail, and a willingness to seek help when needed. But by understanding the process and utilizing available resources, you can fulfill your duties with confidence and ensure that the deceased's wishes are carried out. If you've got any questions or need assistance, feel free to leave a comment below or reach out directly. I'd love to help you navigate this journey. Thanks for watching. Don't forget to like, subscribe, and share this video with anyone who might find it helpful. Until next time, take care.